been sitting here a long while. I think that might be fair. Thank you for that. All right. Well, look, I'd like to ask questions first of all about the Racial Discrimination Act consultation, please. Section 18C proposed changes. So, Attorney, perhaps, or the Department, what was the time frame for consulting on the government's proposed changes to the Racial Discrimination Act?
Well, by that, are you talking about the invitation for public submission?
Yes.
Okay. Well, the invitation was. Thank you. The exposure draft was released for public consultation on the 25th of March, and advertisements were placed then, or a couple of days later, I think it may have been, in the major newspapers inviting public submissions. The consultation period closed on the 30th of April. However, that was a Wednesday and they were still coming in, so we decided to extend it a little bit, and we've closed it at the end of that week on the 2nd of May.
Thank you for that. How many submissions did the department receive?
Look, it was around about 5,300.
Okay, how many were in favour of...
I'm sorry, I'm corrected. It was 5,557.
Good, thank you. How many were in favour of the proposed change and how many were against?
Well, there was a variety of views expressed, Senator, and at the moment I'm going through other submissions. I'm not going to go into the question of this isn't an opinion poll. I'm not going to go into the question of how many were of one point of view or how many were of another. I think it's enough to say that a wide variety of views were reflected in the submissions, as you'd expect, because there's a wide variety of views in the community. There were many who said Section 18C should be repealed entirely and not replaced. There were many who said that Section 18C should be left alone and untouched. And there were many who said, which is the government's view, that Section 18C should be reformed. And within that third category, there was, as you would expect, a wide variety of different views about how the section could be reformed.
So when will the submissions be published?
Well, they won't be published because they were invited on the explicit terms that they were submissions to government that would be treated in confidence. Now, whether or not members of the public or organisations who have made submissions wish to publish them are of course entirely a matter for them, and a number of organisations, including the Human Rights Commission, for example, or the Law Council of Australia, or some of the civil liberties lobbies, or the Institute of Public Affairs, have published their submissions, and that's entirely a matter for them, but it's not for me, as the recipient of submissions invited on the basis that they would be treated by the government in confidence, to breach that confidence by publishing them.
There's a couple of things I'd take up then there. The first question is that I understand from stakeholders that they were of the understanding that if they explicitly, when the submissions were called for, there was an understanding that if they explicitly consented to publication, then indeed they would, rather than the default, which is normally in any inquiry where the public is wanting to know what view is to the inquiry or the consultation, that submissions would be published unless people ask for them not to be published. It's been put to me by stakeholders that they actually understood that if they explicitly consented to the publication of their submissions, that would occur, and in fact quite a lot of stakeholders have actually explicitly put in a clause like that.
Well, they may have done, but that's not the basis on which this was done, and this isn't like making submissions to a parliamentary inquiry. I mean, when the amendments to the Racial Discrimination Act are brought forward by the government later this year, I would be very confident that there would be a Senate hearings into the bill, and before this committee, in fact, and on that occasion, the ordinary process of public submissions to a parliamentary inquiry will no doubt take place, but that's not what this exercise was.
Attorney-General, you would agree, I think, that this question has excited a great deal of interest in the community.
Well, I think that there are a lot of people in the community who feel very strongly about it, one way or another. I wouldn't overstate it, frankly. I think the people who feel strongly about it feel very strongly about it. When I go around my own state, very, very few people raise the issue with me. So I think that this is an issue that has raised a lot of interest among certain groups in the community, but other groups in the community have not engaged in it. But I wouldn't be able to, sort of, as it were, quantify what those are. I'm not an opinion pollster, but I don't think that because a lot of people feel strongly about this, you should assume that it's something that the entire country feels strongly about.
With respect, there's actually a lot of evidence, I think, objective evidence to suggest that that isn't accurate. First of all, there's an opinion poll that showed that 88% of Australians were actually not in favour of the change. There's also this sheer number of submissions that were received, 5,557 in what I've heard just today from you is just over a month.
About 5 weeks, yeah.
So that's actually, I think, an objective indication of the degree to which people were motivated, not just concerned about it, but to write, given that, from what you're saying, there wasn't even an undertaking that those opinions would be made public.
Well, there was more than that. There was an assurance that they wouldn't be, because people do have a right to put their views to government and have their privacy protected.
But the point being that clearly there's a lot of interest. I think it's not it's academic to suggest that it's not.
There are 23 million people in this country, Senator, and 5,500 made submissions. Now, as I said before, I think a lot of people feel very strongly about this. Most of the people who, as it were, come up to me and who approach me on the issue tend to say, what are you doing? Why don't you get rid of Section 18C entirely rather than mucking around with amendments to it? But I acknowledge that there are many other people in the community who would rather see Section 18C left alone. And as I said before, there are people in the middle who think, as I do, that Section 18C is not perfect, that it should be reformed but not repealed.
So with respect, you said earlier in response to one of my questions about publication and how many submissions were in favour, against, so we can look at whether that means in favour totally of what you're proposing, a middle ground of some change or not, no change at all. And you said it's enough to say that there were many, many and many. Now, I would put it to you that actually isn't enough, that people want to genuinely know what their fellow Australians are feeling about this. Many, many, many. Does that mean actually a third, a third, a third? Does it mean 80%?
No, I'm not. I just
want to make sure that you understand, how will we know the proportions of people who are in favour of those three broad stances that you've outlined?
But
Senator, just before you answer, can I just indicate that I'll be absent for the next 5 minutes, and the Deputy Chair, Senator Singh, will be.
Sorry, I think you said 15, so I've got 5 minutes.
Well, Senator, I think you misunderstand the exercise. This was not an opinion poll.
It's a canvassing opinion.
May I please finish my answer to your question, Senator? This was not an opinion poll. This was to solicit views of the community about what was the best way to deal with this matter. We didn't publish embark on an opinion polling exercise. What we did is to ask the community to tell us their ideas. Now, the government went to the election with the announced policy of reforming Section 18C, or as I sometimes put it, repealing Section 18C in its current form. So that's our policy, that's what we're going to do. And for that reason, our policy was not to leave Section 18C unamended, nor was it our policy to repeal Section 18C entirely, as a lot of people would like to see us do. So what I'm particularly interested in are those people who have good ideas about ways in which the section can be improved. And that's what I'm looking for. I'm looking for ideas. This is if I can put it this way, Senator, this is a qualitative, not a quantitative exercise.
But it seems to me that given that there's no commitment to making those interesting ideas known to the general community. This was totally for the benefit of you and your government to understand what people's views are about it. Is that right?
Well, it was, I suppose you might put it that way. I mean, the purpose was to inform the government's thinking by asking people to contribute to that thinking.
I might take you now to the wording of the exposure draft. I understand from, and I'll come to whether or not there might be any change to that, but let's go with what we know at the moment that's there, the exposure draft. I'm interested in knowing who drafted the exposure draft. I'm thinking it may have been all your own work, maybe with a bit of assistance from someone else or a couple of other people, but was Parliamentary Council involved in it at all?
Thanks. Well, it was primarily drafted by me in consultation with the department and with others, yes.
Yes, so did Parliamentary Council cast their eyes over it and give any advice about it?
No, this is not legislation. This is an exposure draft,
I'm just
so that
interested.
wouldn't ordinarily happen.
All right, so I'd like to go, because I've read it, and I
Yes.
read it when you first announced it.
Yes.
And I'm really interested in understanding how it would apply on the ground, and I'm particularly interested in the exemption clause. Extremely wide. I'm wondering who would actually be caught, what comments, what discussion would actually be caught by subsection 4 of that proposed amendment?
Well, Senator, I'm not, as a matter of fact, going to discuss with you or offer my views about the meaning of these provisions because, as is apparent from your earlier questions and as we know, this draft is the subject of review following the contributions that have been generously made by so many people who've taken an interest in the matter. So I think it would be disrespectful, frankly, of the people who have contributed to the process for us to treat this document as having any status other than as it was described, an exposure draft for the purpose of soliciting feedback. Or, as I put it elsewhere, recently the government didn't put this out for discussion with the intention of not listening to what people had to say about it. And that's why we're going through all of these submissions, that some of which, not all of which, but some of which I find very illuminating, just as I found the private discussions I had with certain key stakeholders before that also very illuminating, and I don't think any purpose would be served with me offering my own views about what this document means given the process on which we are now embarked.
It being 3:30, sorry, Senator Wright, it being 3:30,
can I just follow up with a couple more questions on this rather than come back to them? Because I've just got a couple more on that particular issue.
Well, if they're very short and the answers are
I'm happy
short.
to continue if it suits other members.
Well, no, because the other senators want a break. So a couple of minutes, because your 15 minutes is then up.
I appreciate that.
Okay.
I've been waiting a long time for this chance, so thank you for that. With respect, Attorney-General, this was put out in good faith as a statement of what the proposal was. It was an exposure draft. You invited comments on it.
That's right.
But I think that I would suggest that the community is entitled to understand the thinking behind it, and in a sense, clearly presumably you felt an exemption of some kind was necessary.
Yes.
The width and the breadth of the exemption has excited a lot of interest, given that we will be looking at some further potentially changes to it. I'm interested in knowing, given that this was put out as a serious document, and this is my first chance to ask you about it, what would be caught in terms of behaviour that was not acceptable or appropriate by this extremely broad description of what the exemption would be? I mean, it doesn't take a lawyer to actually see that it's... Well, I'm really quite interested in the course of participating in the public discussion. My question would be, does that include a discussion in the city square? Does it include a discussion in a workplace? Is that a public discussion?
Well,
does it include a discussion on television or on public transport?
As a matter of fact, Senator, that expression on which you've fixed doesn't really take the matter very far, because the existing Section 18C actually also only applies to public acts, or acts, as it were, and to use the vernacular expression, in the public square.
But it's a far broader range of behaviours that are caught, whereas this exempts. There's a lower bar in a sense.
Well,
a higher bar for
you may think that, but you asked, perhaps it might be helpful if I approach a question this way, Senator. You asked what the thinking was behind this. Now, I have tried to explain this in answer to questions from Senator Singh, yes, Senator Singh and Senator Peris, and I thought perhaps from you, Senator, but anyway, from a Green senator in the chamber. The thinking is that the existing Section 18, my thinking is that the existing Section 18C is imperfect for two principal reasons. Not saying these are the only reasons, but they're the main ones. First of all, because it is, in my view, way too restrictive of freedom of speech and freedom of discussion. And secondly, because although it purports to deal with racist language, it actually doesn't provide for racial vilification, which is the core concept here. So it's, in a sense, it fails in its current wording at both hurdles. It doesn't provide effective protection against racial vilification, which is the core mischief to which it's meant to be addressed. And because of the way it's worded, it is, in the government's view, way too restrictive of freedom of discussion.
But the exemption itself that you proposed in the exposure draft, the question I come back to is, what area of public discourse or public behaviour, what wouldn't that exemption apply to? What's left? And that's the question that many people have been asking.
The exemption wouldn't exempt, for example, racial abuse. It wouldn't exempt racial vilification.
Words, sounds, images or writing spoken, broadcast, published or otherwise communicated in the course of participating in the public discussion of any political, social, cultural, religious, artistic, academic or scientific matter. So the question I had was an example of
I don't regard the utterance of a racist jibe, for example, or racial vilification as words uttered in the public discussion of a matter.
What about a discussion on it? Just last
well,
question. What about a discussion
at 25-2, which is in 30 seconds?
What about a discussion on public transport where there's a discussion that tends to be around a person of a particular appearance and a general discussion that someone invites the other passengers on public transport to engage in about the merits of a particular race, their attributes, their characteristics? I would suggest that would be caught within that. It's in the course of public discussion. It's any political matter.
You're entitled to your view, Senator.
Well, I'm asking you.
You're entitled to your view, Senator. But the point I make to you is that the same could be said for the existing Section 18C.
All right. At that